I stood in the mailroom at the Cottages at Willow Glen Community HOA in Bellevue, Washington, staring at the violation notice taped to my mailbox slot, and the first thing I felt was pure disbelief. I had moved here 6 months ago because the condo was affordable and close to the courthouse where I work as a court interpreter, translating depositions and hearings 5 days a week. The HOA had seemed fine at first, maybe a little strict about parking and trash schedules, but nothing that screamed trouble. The neighborhood was a mixed setup, renters in some units and owners in others, and I had heard whispers that the board treated renters like second-class citizens, but I owned my place outright, so I figured I was safe. I was wrong. The notice claimed I was responsible for clearing snow from a fire hydrant near my corner unit, the one buried under a 3-foot drift after the ice storm 2 nights ago, and it threatened fines starting at $50 per day if I did not comply within 72 hours. My refinance application was sitting with the underwriter right now, waiting on final approval, and any lien threat over unpaid fees could kill the deal and cost me thousands in locked interest rates. The notice was signed by Donna Hughes, the rules enforcement chair, a woman everyone called Patricia behind her back because she had that exact energy. I pulled out my phone and took a photo of the notice, then walked outside to look at the hydrant. The corner of the property was a wind tunnel, and the plow crew had shoved all the street snow into a massive berm that covered the hydrant completely. Only the rounded yellow dome of the cap was visible, like a submarine periscope poking through Arctic ice. I had never touched this hydrant, never parked near it, never even thought about it. It was city property, sitting in the public right-of-way between the sidewalk and the curb. I pulled up the municipal code on my phone and confirmed it. Fire hydrants are the responsibility of the City Public Works Department, not private property owners. I screenshot the statute and forwarded it to the HOA management company email listed on the notice, along with a polite note explaining the error. The management company replied 2 hours later with a form letter that said winter staffing was thin and delays were normal, and that I should address my concerns directly with the board at the next meeting. The meeting was not for 3 weeks. The 72-hour deadline was in 2 days. I called the office and got voicemail. I called again an hour later and got the same recording. I forwarded the city statute again, this time marking it urgent, and heard nothing. By the end of the day, I was furious, but also calculating. I know how hearings actually go because I sit in courtrooms translating procedural warfare 5 days a week, and this had all the hallmarks of someone setting up a paper trail to justify escalation. Patricia was skipping steps on purpose, and I needed to prove it. That night, I drove to a neighbor's unit 2 buildings over. His name was Marcus, a renter who worked as an advocate helping other renters fight lease violations and unfair treatment. I had met him at a community barbecue in the fall, back when the weather was decent and people still talked to each other. He opened the door holding a mug of coffee and waved me inside. I showed him the notice and the email thread. He read it carefully, then nodded. "Marcus, this feels like a setup. She is ignoring the city code and rushing the deadline." He leaned back and sighed. "Patricia does this all the time. She loves sending violation notices, especially to people she thinks will not fight back. Last year, she tried to fine a renter for parking in a guest spot overnight, claimed it was reserved for owners only, even though the lease and the covenants say guest spots are first come, first served. I helped the renter file a complaint with the management company, and Patricia backed off, but only after the renter threatened to lawyer up. I asked what my options were. Marcus said I could request a formal hearing, but the process was rigged. The board would reset deadlines, claim I missed filings, and charge me administrative fees for every step. He suggested I start building a case now, documenting every interaction and filing public records requests to see if there were other complaints against Patricia or the management company. I took his advice and submitted a records request that night through the county website, asking for any complaints, arbitration filings, or enforcement actions related to the Cottages at Willow Glen Community HOA over the past 3 years. The records came back 5 days later, a thick PDF with dozens of entries. Multiple homeowners and renters had filed complaints alleging discriminatory enforcement, harassment, and procedural violations. One case involved Patricia personally calling a towing company to remove a vehicle that was legally parked, then refusing to reimburse the owner for the tow fees. Another case showed the board had denied pool access to a renter as punishment for complaining about a leaky roof, claiming the renter had violated a noise ordinance that did not exist in the governing documents. I printed the whole file and highlighted every entry that mentioned Patricia or the management company. This was my evidence, the proof that the HOA had a pattern of weaponizing disputes by resetting deadlines and inventing violations. But I did not send it to anyone yet. I acted like I was backing down, because timing was the whole weapon. If I revealed what I had too early, Patricia would just pivot and cover her tracks. I needed her to escalate further, to commit herself to a position she could not walk back from, and then I would deploy the proof in a way that left her no room to maneuver. The 72-hour deadline passed. I did not shovel the hydrant. I did not hire a crew. I did nothing. 2 days later, another notice appeared on my mailbox. This one said my pool and gym access had been revoked due to non-compliance with fire safety regulations. I went to the gym that afternoon and swiped my key fob. The reader blinked red and beeped 3 times. A sign taped to the door said access suspensions would remain in effect until all violations were cured and all fines paid in full. I took a photo of the sign and the red blinking reader, then walked back to my unit. That same afternoon, I got an email from Patricia directly. It was short and brutal. "You are not special, you are just loud. You will pay every fee we say you owe, or we will place a lien on your property and begin foreclosure proceedings. Compliance is not optional." I read it twice, then forwarded it to Marcus without comment. He called me 10 minutes later. "She just gave you gold." That is explicit retaliation, and the lien threat over a disputed city property issue is probably illegal. Save that email. Print it. We are going to use it. I printed 3 copies and filed them in a folder with the public records log and the city statute. Then I replied to Patricia with a calm, professional email asking for a copy of the specific HOA rule or covenant that made me responsible for the hydrant. I cited the city code again and requested a formal hearing to dispute the violation. I kept my tone neutral, almost apologetic, like I was just confused and wanted to understand. Her reply came an hour later. "The governing documents are available for review at the management office during business hours. Your hearing request is noted. You will be contacted with a date and time." 3 days later, I got a new email from the management company. My hearing was scheduled for 6 weeks out, a full month past the original 72-hour deadline. The email also informed me that my amenity suspension would remain in effect until the hearing concluded and any fines were paid. I was furious, but I stayed quiet. This was exactly what Marcus had warned me about. The board was resetting deadlines to run out the clock and pile on fees. Every day I waited was another $50 in fines, at least according to their notices. By the time the hearing happened, they would claim I owed thousands, and the lien threat would become real. My refinance deadline was ticking down too. The underwriter had requested an HOA compliance letter, a standard document confirming there were no outstanding violations or unpaid fees. I called the management company and asked for the letter. The receptionist put me on hold for 8 minutes, then came back and said the letter could not be issued while there were open enforcement actions on my account. I explained that the violation was under dispute and asked if they could note that in the letter. She said no. I asked to speak to a supervisor. She said supervisors were only available by appointment, and the next available slot was in 2 weeks. I hung up and immediately called my mortgage broker. I explained the situation, and she said bluntly that if the compliance letter did not arrive within 10 days, the underwriter would likely pull the approval and I would lose my rate lock. I sat in my living room that night staring at the folder of evidence and realized I was out of time. I could not wait for the hearing. I needed to force a confrontation now, on my terms, and I needed to make sure Patricia walked into an ambush she could not escape. The next morning, I composed an email to every homeowner and renter in the cottages at Willow Glen community. The HOA had a directory listed on the community website, complete with email addresses for anyone who had opted in. I copied the whole list, about 70 people, and sent them a message with the subject line: Enforcement Policy Violations and Retaliation by Board Chair. In the body, I laid out the timeline, the fire hydrant notice, the city statute proving the hydrant was not my responsibility, Patricia's refusal to acknowledge the statute, the amenity suspension, the lien threat, and the public records log showing a 3-year pattern of similar abuses. I attached the records PDF, the city code screenshot, Patricia's email with the line "You will pay every fee we say you owe," and a copy of the enforcement policy from the governing documents that clearly stated warnings must be issued before suspensions, and hearings must be scheduled within 14 days of a dispute request. Patricia had skipped the warning step entirely and delayed my hearing by 6 weeks. I ended the email with a simple line: "The next board meeting is this Thursday at 7 p.m. in the clubhouse. I will be there, and I hope you will be too." I hit send and felt my heart hammering. This was the trump card deployment, the moment I had been holding back for, and now it was out in the open where Patricia could not bury it. The responses started within minutes. A dozen people replied to thank me, saying they had experienced similar issues and were glad someone was finally speaking up. One owner forwarded me a notice she had received last winter, nearly identical to mine, threatening fines over a snow-covered mailbox that was actually the Postal Service's responsibility. Another renter said Patricia had tried to ban him from using the guest parking after he filed a maintenance request for a broken heater. By midday, my inbox was flooded, and the community email list was lighting up with a thread that the management company could not shut down because it was hosted on an external platform. Thursday arrived. I dressed carefully that morning, putting on a button-down shirt under my charcoal gray puffer jacket, and made sure I had my folder of evidence, my phone fully charged, and a small voice recorder I used for work depositions. I arrived at the clubhouse 15 minutes early. The room was already half full. Marcus was there, sitting in the front row, and he nodded at me as I walked in. I recognized a few other faces from the email thread, people who had replied with their own stories. The board table was set up at the front, 5 chairs behind a folding table with a gavel and a stack of binders. Patricia was not there yet. She arrived at 7 sharp, walking in through the side door with a reflective armband strapped over her teal puffer coat, the same band she always wore when directing the tow truck during snow events. It had become her signature, a little power symbol that said she was in charge of enforcement. She wore a red knit hat pulled low, and her tight medium brown curls framed a face that was already set in a scowl. She saw the crowd and froze for half a second, then recovered and walked to her seat at the center of the table. The other board members filtered in behind her, looking confused by the turnout. Patricia called the meeting to order and started with the standard agenda items: budget review, landscaping contracts, pool maintenance schedule. People shifted in their seats, impatient. After 10 minutes, Marcus stood up and interrupted. "Excuse me, but a lot of us are here to discuss enforcement policies and retaliation issues. Can we move that to the top of the agenda?" Patricia's face went red. "This is not an open forum. If you have a complaint, you can submit it in writing and request a hearing." Marcus did not sit down. Several of us have already submitted complaints and been ignored or delayed. We got an email this week from a homeowner who documented a pattern of procedural violations, and we want answers tonight. The room murmured in agreement. Patricia looked at the other board members, but they just stared back, clearly not prepared for this. She turned to me. "Are you responsible for that email?" I stood up. "Yes. I sent it because you have been violating the enforcement policy and retaliating against me for disputing a fire hydrant notice that the city code clearly says is not my responsibility." Patricia slammed her hand on the table. "You are not special. You are just loud. You refuse to comply with a direct safety order, and the board has every right to suspend your privileges and assess fines." I pulled out my folder and held up the city statute. This is the municipal code. Fire hydrants in the public right-of-way are the city's responsibility. I sent this to you and the management company multiple times, and you ignored it. You also skipped the required warning step in the enforcement policy and delayed my hearing by 6 weeks, which violates the 14-day rule in the governing documents. Patricia stood up, her voice rising. "The board has discretion to interpret the governing documents as needed to protect the community. If you do not like it, you can take it up with a judge." I stayed calm. "I also have a copy of the public records log showing that you have done this to multiple residents over the past 3 years. Fake violations, illegal towing, amenity bans as punishment. This is not about safety. This is about control." The room erupted. People started shouting questions at Patricia, asking about their own cases, demanding accountability. One woman stood up and said Patricia had threatened to fine her for having a holiday wreath on her door, claiming it was a prohibited yard display, even though the covenants only restricted permanent structures. Another man said Patricia had called a towing company to remove his son's car during Thanksgiving, claiming it was abandoned, even though it was parked legally in a guest spot with a visitor pass clearly displayed. Patricia tried to gavel the meeting back to order, but the noise was overwhelming. She shouted over the crowd, "If you do not like how this community is run, you can move. The board will not be bullied by a mob." Marcus stood again. "This is not a mob, this is your community, and you work for us. The governing documents require transparency and due process, and you have been violating both. We are not asking for special treatment. We are asking you to follow your own rules." Patricia grabbed her binder and her coat. "This meeting is adjourned. If you want to file a formal complaint, submit it in writing." She walked toward the door, but I was ready. I raised my voice. "Before you leave, I want to make sure the minutes reflect that I am requesting the public records log be read into the record as evidence of a pattern of enforcement abuse. I also want to note that you sent me an email stating, 'You will pay every fee we say you owe, or we will place a lien on your property and begin foreclosure proceedings,' despite the fact that the violation was under dispute and involved city property. That email is attached to the documentation I sent to the community, and I am requesting it be included in tonight's minutes as well." Patricia stopped and turned around. Her face was purple. "You are twisting everything to make yourself look like a victim. The board has the authority to enforce the rules, and you are in violation. End of story." I met her eyes. "Then explain why you skipped the warning step. Explain why you delayed my hearing by 6 weeks. Explain why you suspended my amenities without a hearing. Explain why the enforcement policy you are supposedly following says none of that is allowed." She did not answer. She just stared at me, and I could see her realizing that she had walked into exactly the trap I had set. She had escalated too far, too fast, and now there were 70 witnesses and a paper trail she could not erase. One of the other board members, an older man I did not recognize, cleared his throat. "Patricia, maybe we should table this and consult with the attorney before we proceed." Patricia ignored him and pointed at me. "You think you are clever, but you do not understand how this works. The board has insurance. We have legal protection. You have nothing." I pulled out my phone and held it up. "I have recordings of every interaction, screenshots of every email, and a public records log that proves you have been doing this for years. I also have a mortgage underwriter who is waiting on an HOA compliance letter, and your refusal to issue one while you pursue a fraudulent violation is going to cost me thousands of dollars in interest. That is not enforcement. That is retaliation, and it is illegal." The room went silent. Patricia looked around, and I could see her calculating her next move. Finally, she turned to the board secretary. "Note in the minutes that this matter will be referred to the HOA attorney for review." Meeting adjourned. She walked out, and the reflective armband caught the fluorescent light as she pushed through the door. The crowd started talking all at once, some people coming up to thank me, others surrounding the remaining board members with questions. Marcus clapped me on the shoulder. "You just ended her. That was perfect." I did not feel victorious yet. I knew Patricia was not done. The next morning, I got a call from the management company. The voice on the other end was clipped and professional. "This is Julie from Cascade Property Management. We have been reviewing your account, and we need to inform you that your amenity suspension will remain in effect pending the outcome of the board's legal review. Additionally, we are assessing a $150 administrative fee for the special meeting disruption last night." I kept my voice level. There was no disruption. I responded to questions from other homeowners during an open meeting. The board called the adjournment, not me. Julie sighed. "Regardless, the fee has been added to your account. If you wish to dispute it, you will need to submit a written appeal." I hung up and called Marcus. "They are doubling down." He was not surprised. "Patricia is trying to exhaust you. She knows the fees are garbage, but she is betting you will either pay them to make it stop, or you will give up and move. I am not giving up, and I am not paying fraudulent fees." Good. Then we escalate. That afternoon, Marcus helped me draft a formal complaint to the Washington State Attorney General's office, alleging HOA governance violations and consumer protection issues. We also filed a complaint with the County Housing Authority, citing the discriminatory treatment of renters and the pattern of retaliation documented in the public records log. Both complaints included the full evidence packet, the emails, the notices, the records log, the enforcement policy, and the city statute. We requested an investigation and asked that the HOA be required to submit to third-party oversight until the governance issues were resolved. 2 days later, I was walking to my car after work when I saw Patricia standing by the mailbox cluster, talking to a man in a reflective safety vest. He was holding a clipboard and gesturing toward the fire hydrant on the corner. I slowed down and pulled out my phone, recording video as I approached. Patricia saw me and her expression hardened. She said something to the man, and he walked toward a white pickup truck parked at the curb. I kept recording as I got closer. "Patricia, what is going on?" She crossed her arms. "The board has hired a contractor to clear the hydrant and bill you for the service. Since you refuse to comply, we are exercising our right to remedy the violation and assess the cost to your account." I stopped a few feet away, keeping the phone steady. The hydrant is city property. The contractor has no authority to bill me for work on public infrastructure. The man in the vest walked back over. "Excuse me, are you the property owner?" I turned the camera toward him. "I own a unit in this complex, yes, but the fire hydrant is not on my property. It is in the public right-of-way, which means it is the city's responsibility. Did the HOA explain that to you before you agreed to do the work?" He looked at Patricia, then back at me. "I was told the property owner was responsible for clearing it. Do you have a copy of the work order?" He hesitated, then pulled a sheet from his clipboard. I took a photo of it with my phone, then looked at him. "This work order lists my unit address, but the hydrant is not located on my property. It is on city land. If you do the work and try to bill me, I will dispute it, and I will file a complaint with the City Public Works Department for unauthorized maintenance on municipal infrastructure. You might want to check with your own insurance before you proceed." The contractor looked at Patricia. "Is that true?" Patricia's face went red. The HOA has the authority to maintain common areas and assess costs to homeowners who fail to comply with safety regulations. The contractor shook his head. "Lady, if the hydrant is city property, I am not touching it. I am not getting sued because you did not do your homework." He walked back to his truck, tossed the clipboard onto the passenger seat, and drove off. Patricia stood there, staring at me, and I could see her jaw clenching. "You just cost the HOA money," Patricia said quietly. "That contractor charges a cancellation fee. You cost the HOA money by hiring him without checking the facts. I gave you the city statute a week ago. You ignored it." She stepped closer, her voice dropping to a hiss. "You think you are winning, but you are not. The board has options you have not even thought of yet. You will pay every fee we say you owe, one way or another." I kept the phone recording. "Are you threatening me?" She smiled, cold and sharp. "I am informing you of the consequences of non-compliance. That is not a threat. That is a fact." I turned and walked back to my car, the phone still recording. As I got in and started the engine, I saw her pull out her own phone and make a call, her face tight with anger. That night, I got an email from the management company. Effective immediately, my vehicle access code for the community gate had been deactivated due to ongoing violations and unpaid fees. The email said I could park on the street outside the complex until my account was brought current. I read it twice, then checked the weather forecast. A major ice storm was predicted to hit that weekend, with freezing rain and potential power outages. If my car was locked outside the gate during the storm, it could be buried under ice for days, and I would have no way to get to work. I called Marcus. They just locked me out of the gate. He swore under his breath. "That is insane. They cannot restrict your access to your own property over a disputed fine." They just did. "Okay. We need to document this. Next time you try to enter, record everything. If they actually lock you out during the storm, that is grounds for an emergency injunction. I know a housing attorney who might take this on contingency if we can show immediate harm. The storm hit Friday night. By Saturday morning, the entire complex was coated in a half-inch layer of ice. Trees sagged under the weight, and the streets were slick and dangerous. I had parked on the street Friday afternoon, anticipating the lockout, but I needed to get inside the gate to check my unit and make sure the pipes had not frozen. I drove to the entrance and punched in my access code. The gate did not move. I tried again. Nothing. I pulled out my phone and started recording, narrating the date, time, and situation as I tried the code a third time. The keypad just blinked red. I called the management company emergency line. A recorded message said the office was closed for the weekend and to call back Monday. I called Marcus. He told me to drive to the pedestrian entrance and try to walk in, recording the whole time. I parked on the street and walked to the side gate. It was locked too, and the keypad gave the same red blink. I recorded myself trying the code, then narrating that I was locked out of my own property during a severe weather event with no way to check for frozen pipes or retrieve essential items. As I stood there, a car pulled up to the vehicle gate from inside the complex. The driver rolled down her window and called out, "Are you locked out?" I walked over. Yes. My access code was deactivated yesterday. She shook her head. Patricia did that to another owner last month. He had to threaten legal action to get it turned back on. Do you want me to let you in? I hesitated, then nodded. That would be incredible, thank you. She waited while I jogged back to my car, then waved me through when she opened the gate with her code. I drove in and parked in my assigned spot, my heart pounding. I went inside my unit and checked the thermostat and the pipes. Everything was fine, but the fact that I had been locked out at all, especially during an ice storm, was evidence of retaliation so blatant it was almost funny. I spent the rest of the weekend documenting everything. Photos of the ice-coated gate, the red blinking keypad, the weather forecast showing the storm warnings, and the timeline of emails and notices leading up to the lockout. Monday morning, I sent the entire packet to the housing attorney Marcus had recommended, along with a request for an emergency hearing to restore my access and stop the harassment. The attorney, a sharp woman named Laura Chen, called me that afternoon. This is one of the most aggressive HOA retaliation cases I have seen in years. The gate lockout alone is probably enough for an injunction. The fire hydrant stuff is almost comedic. I am going to file a petition for a temporary restraining order against the board chair personally, and I am going to request that the court order the HOA to restore your access and cease all enforcement actions until this is resolved. Are you prepared for this to get ugly? It is already ugly. Good. Then let's finish it. Laura filed the petition Tuesday morning. The hearing was set for Thursday afternoon in Bellevue District Court. I took the day off work and met Laura at the courthouse. Patricia was there with the HOA attorney, a tired-looking man in a rumpled suit who clearly had not been briefed on the specifics. Laura presented our evidence, the city statute, the public records log, the enforcement policy violations, the gate lockout during the ice storm, and Patricia's emails threatening liens and foreclosure. The judge, a no-nonsense woman in her 50s, read through the packet with increasing disapproval. She looked at the HOA attorney. Does your client dispute that the fire hydrant in question is located in the public right-of-way and is therefore the responsibility of the city? The attorney glanced at Patricia, then back at the judge. Your Honor, the HOA's position is that the governing documents give the board discretion to enforce safety regulations as they see fit. That is not what I asked. Is the hydrant on city property or not? He hesitated. Based on the municipal code submitted by the petitioner, it appears the hydrant is on city property. Yes. The judge set down the papers. Then on what basis did your client issue a violation notice and suspend the petitioner's amenities? The attorney had no answer. The judge turned to Patricia. Ma'am, did you personally deactivate this man's gate access code? Patricia lifted her chin. The board voted to suspend access pending resolution of unpaid fees. During an ice storm. Patricia did not respond. The judge shook her head. I am granting the temporary restraining order. The respondent, Donna Hughes, is prohibited from contacting the petitioner directly or indirectly, from issuing any further violation notices related to the fire hydrant, and from restricting the petitioner's access to the property or its amenities. The HOA is ordered to restore full access immediately and to remove any fines or fees associated with the fire hydrant dispute. A full hearing on the harassment allegations will be scheduled within 30 days. This is one of the clearest cases of retaliatory enforcement I have seen, and if the evidence holds up at the full hearing, I will consider sanctions. Patricia stood up, her face white. Your Honor, the board was acting in good faith to protect the community. The judge cut her off. Good faith does not include locking someone out of their home during a winter storm over a dispute involving city property. The restraining order is in effect immediately. You are dismissed. Patricia walked out without looking at me. Laura shook my hand. That went better than I expected. The full hearing will be a formality at this point. Do you want to pursue damages? I thought about it. What are my options? She pulled out a notepad. You can sue for emotional distress, lost time from work, the cost of defending yourself, and possibly punitive damages if we can prove malice. Based on the emails and the gate lockout, I think we have a solid case for punitive. You could be looking at mid-5 figures, maybe more if the jury does not like her. I nodded slowly. Let's do it. The full hearing happened 3 weeks later. By then, the story had spread through the complex like wildfire. A local news blog picked it up, running a piece about HOA overreach and retaliation, and suddenly, Patricia was the face of petty tyrant boards across the region. The HOA held an emergency meeting and voted to remove her from the rules enforcement chair position. She resigned from the board entirely a week later. At the full hearing, Laura presented the complete evidence file, including testimony from Marcus and 2 other homeowners who had been targeted by Patricia in previous years. One of them, the woman who had been threatened over the holiday wreath, testified that Patricia had admitted in an email that she wanted to make an example of people who questioned the board's authority. The judge awarded me $42,000 in damages, citing the egregious nature of the harassment and the clear evidence of retaliation. The HOA's insurance covered most of it, but the board was required to issue a formal apology and implement new oversight policies to prevent future abuse. The restraining order became permanent. Patricia was barred from contacting me, attending any HOA meetings where I was present, and serving in any HOA leadership role for 5 years. The management company was replaced after the County Housing Authority investigation found multiple violations of state HOA governance laws. My refinance went through 2 weeks after the temporary restraining order was granted. The new management company issued the compliance letter without hesitation, noting that all disputes had been resolved in my favor and there were no outstanding violations or fees on my account. I still live at the cottages at Willow Glen Community. The new board is not perfect, but they follow the rules, and the enforcement process actually works the way it is supposed to. Marcus and I became close friends, and we co-chair a resident advisory committee that reviews all enforcement actions before they are finalized. It is not glamorous work, but it matters. The fire hydrant is still on the corner, and the city clears it every winter now, just like they are supposed to. I walk past it most mornings on my way to the car, and every time I see that yellow dome poking through the snow, I think about Patricia and her reflective armband, and the look on her face when the judge told her she had crossed a line she could not uncross. She moved out of the complex 6 months after the final hearing. I heard through the grapevine that she bought a house in a neighborhood with no HOA, which felt like poetic justice. Marcus joked that she probably tried to start her own shadow board within a week, but I never followed up to find out. The whole experience taught me something I already knew from years in courtrooms but had never applied to my own life. Documentation is everything. Timing is a weapon, and the people who love power the most are usually the ones least equipped to handle it when it gets taken away. I kept every email, every notice, every recording. I still have the folder, filed in a cabinet in my office, and sometimes I pull it out just to remind myself that standing up to bullies is not about being loud or special. It is about being patient, being thorough, and knowing when to deploy the proof that leaves them no room to lie. You are not special, Patricia had said. You are just loud. She was wrong. I was not loud. I was prepared. And in the end, that made all the difference. The neighborhood settled into a new normal after Patricia left. The new board chair was a retired engineer named Tom who treated the governing documents like a technical manual. No emotion, no favoritism, just the rules as written. It was boring in the best way. Violation notices became rare, and when they were issued, they followed the process exactly. Warning, opportunity to cure, hearing if disputed, no shortcuts. The community email list went quiet, which was a relief after months of daily drama. But the legal system moved slowly, and even after the restraining order and the damages award, there were still loose ends. Patricia filed an appeal, claiming the judge had been biased and the evidence was inadmissible. Her new attorney argued that the emails and recordings had been taken out of context and that the board had acted within its legal authority. Laura was not worried. She said appeals like this almost never succeeded, especially when the trial record was as clean as ours, but it still meant more waiting, more legal fees, and more time spent looking over my shoulder. The appeal hearing was scheduled for late March, almost 4 months after the original judgment. I did not have to attend, but I wanted to be there. Laura said it was not necessary, that appellate hearings were dry and procedural, but I felt like I owed it to myself to see it through to the end. The hearing was held in a small courtroom in downtown Seattle, wood-paneled and formal, with 3 appellate judges sitting at a raised bench. Patricia was not there, which surprised me. Her attorney, a younger man with slicked-back hair and an expensive suit, presented the appeal arguments in a calm, clinical tone. He argued that the trial judge had overstepped by imposing a restraining order based on civil disputes rather than criminal harassment, and that the damages award was excessive given that no physical harm had occurred. Laura countered with the trial record, walking the judges through the timeline of escalation, the procedural violations, the gate lockout during the ice storm, and Patricia's own emails threatening liens and foreclosure. She emphasized that the harm was not physical but economic and emotional, and that the pattern of retaliation was so clear and deliberate that punitive damages were not only justified but necessary to deter similar conduct by other HOA boards. The judges asked a few questions, mostly about the gate lockout and whether the HOA had any legitimate basis for deactivating my access. Patricia's attorney tried to argue that the lockout was a clerical error, not intentional retaliation. But Laura pulled up the email from the management company explicitly stating that access had been revoked due to ongoing violations. One of the judges, a sharp-eyed woman with reading glasses on a chain, leaned forward and asked Patricia's attorney if he was seriously suggesting that deactivating someone's gate code during an ice storm could ever be considered a clerical error. He did not have a good answer. The panel took the case under advisement and said a ruling would be issued within 60 days. Laura and I walked out of the courthouse into a cold drizzle, and she told me she was confident the appeal would be denied. I believed her, but I also knew that confidence was not the same as certainty. The ruling came back 7 weeks later. The appellate court denied the appeal in a terse 2-page order, affirming the trial court's findings and noting that the evidence of retaliatory conduct was overwhelming. The restraining order and damages award were upheld in full. Laura called me with the news, and I felt a weight lift that I had not realized I was still carrying. "That should be the end of it," she said. "Patricia has no further avenues of appeal, and the judgment is final. The HOA's insurance will cut the check, and you can move on." I thanked her and hung up, and for the first time in months I felt like the story was actually over. But there was one more twist I did not see coming. 2 weeks after the appellate ruling, I got a call from a man who introduced himself as a reporter for a regional public radio station. He said he had been following the case through court filings and wanted to do a story about HOA governance abuse and what homeowners could do to protect themselves. He asked if I would be willing to be interviewed, along with Marcus and a few other people who had been targeted by Patricia. I hesitated. The legal fight was over, and I did not particularly want to relive it on the radio. But Marcus convinced me that the story could help other people who were dealing with similar situations, and that visibility might pressure other HOA boards to think twice before pulling the same stunts. The interview was recorded in a small studio in Seattle. The reporter, a calm woman named Allison, asked straightforward questions about the timeline, the evidence, the legal process, and what I had learned. I kept my answers factual and unemotional, focusing on the importance of documentation and knowing your rights. Marcus was interviewed separately, and he talked about the systemic issues with HOA governance and the lack of oversight that allowed boards to operate like petty fiefdoms. The story aired 3 weeks later, a 12-minute segment during the afternoon news magazine show. It was fair and balanced, presenting the facts without editorializing, and it included a brief response from the HOA's new board chair, Tom, who acknowledged that the previous board had made serious mistakes and that reforms were underway. The response was immediate. My inbox filled with messages from people across the state and even a few from other parts of the country, sharing their own HOA horror stories and asking for advice. Some of them were dealing with situations that made mine look tame. Boards that had foreclosed on homes over trivial violations. Management companies that had embezzled funds. Architectural committees that had denied reasonable requests out of spite. I forwarded the most urgent cases to Laura, and she connected several of them with other housing attorneys who specialized in HOA disputes. The publicity also had an unexpected side effect. The state legislature had been debating a bill to strengthen HOA oversight and require third-party audits for boards with a history of complaints. The bill had been stalled in committee for months, but after the radio story aired, it picked up momentum. A coalition of homeowner advocacy groups used the story as a rallying point, and the bill passed both chambers within 6 weeks. The governor signed it into law in late May. I did not testify at the hearings or lobby for the bill. I was not interested in becoming a crusader or a public figure. But Laura told me later that my case had been cited multiple times during the floor debates as an example of why the reforms were necessary, and that felt like a meaningful legacy. By summer, the complex was unrecognizable. The new management company had repainted the clubhouse, upgraded the gym equipment, and repaved the parking lot. The pool reopened with new hours and no arbitrary access restrictions. The board published a monthly newsletter with transparent financials and meeting minutes, and they started hosting quarterly town halls where residents could ask questions and raise concerns without fear of retaliation. Marcus and I continued to co-chair the Resident Advisory Committee, and we used the platform to push for policies that treated renters and owners equally. We rewrote the enforcement guidelines to require warnings before fines, mandatory hearings within 14 days of a dispute, and clear appeals processes with third-party review. It was not glamorous work, but it mattered, and it felt like we were building something that would outlast both of us. Patricia never returned to the complex, and I never saw her again. I heard through the grapevine that she had tried to join the board of her new neighborhood association, but had been quietly turned away after someone ran a background check and found the restraining order. I did not take any satisfaction in that. I just felt tired. The damages check arrived in June, a wire transfer that hit my account on a Tuesday morning. $42,000, minus Laura's contingency fee and some administrative costs, left me with just over $28,000. I used part of it to pay off my car, part of it to build an emergency fund, and part of it to donate to a nonprofit that provided free legal aid to low-income homeowners and renters fighting HOA abuse. It felt like the right way to close the loop. I kept working as a court interpreter, translating depositions and hearings, and every time I sat in a courtroom and watched attorneys argue over procedural violations or evidentiary standards, I thought about my own case and how close I had come to losing simply because I did not know the rules. Knowledge is power, but only if you use it, and only if you are willing to stand your ground when the people in charge try to steamroll you. The reflective armband became a running joke in the complex. Someone made a meme out of it and posted it in the community Facebook group, a photoshopped image of Patricia directing traffic with the caption, "You will pay every fee we say you owe." It was mean-spirited, but it was also cathartic, and I did not feel bad for laughing. The fire hydrant is still there on the corner, bright yellow and fully cleared every winter. The city installed a small flag marker next to it after the case went public, a little piece of bureaucratic compliance that probably would not have happened if I had not made noise. I walk past it most mornings, and every time I do, I remember the moment I stood in the snow with my phone out, recording Patricia and the contractor, knowing that I was building the case that would end her petty tyranny. The restraining order is still in effect, and it will be for another 4 years. I doubt Patricia thinks about me much anymore, but I think about her sometimes, usually when I see someone else getting pushed around by a petty authority figure and I wonder if they know they have options. Most people do not. Most people assume the board is all-powerful, that the rules are whatever the board says they are, and that fighting back is hopeless. I used to think that too. But I was wrong. The rules are written down, and they apply to everyone, even the people enforcing them. The trick is knowing where to look, how to document, and when to deploy the proof that leaves no room for lies. You are not special, Patricia had said. You are just loud. She was right about one thing. I am not special. I am just someone who knew how to read the governing documents, how to file a public records request, and how to sit in a courtroom and watch procedural warfare unfold until I understood the weapons well enough to use them myself. And in the end, that was enough. The snow came back the following winter, heavy and relentless, and the complex transformed into the same frozen landscape that had started everything. But this time, there were no violation notices, no gate lockouts, no threats. The board followed the rules, the management company did their job, and the residents trusted that disputes would be handled fairly. It was not perfect. There were still complaints, still disagreements, still moments of frustration. But it was functional, and that was more than enough. I stood at my window one evening in late January, watching the snow fall in thick, quiet flakes, and I thought about how close I had come to losing everything over a fire hydrant I never touched. The refinance, the legal fees, the stress, the fear. It had all been real, and it had all been avoidable if just one person in a position of authority had been willing to admit a mistake. But that is not how power works. Power does not admit mistakes. Power doubles down, escalates, and tries to bury you under paperwork and fees and threats until you give up or give in. Unless you fight back. Unless you document everything, find your allies and deploy your proof at exactly the right moment. I turned away from the window and went back to my desk, where the folder of evidence still sat in the top drawer. I pulled it out and flipped through the pages one last time, the emails, the notices, the public records log, the city statute, the photos, the recordings. It was all still there, a paper trail of petty tyranny, and the proof that ended it. I closed the folder and put it back in the drawer. I did not need to look at it anymore, but I was not ready to throw it away either. It was a reminder, a monument to the fight, and a warning to anyone who thought they could push me around again. You are not special, Patricia had said. No, I thought. I am not. But I am thorough. I am patient. And I know how to win. And that is all I ever needed to be.